Welcome back, everybody, to the Lex Rex Institute podcast. It's been a hot minute since our last episode, so hopefully we have lots of exciting stuff planned for you guys today. What's our subject we're discussing, David?
Well, we've got a few things. The main topic is going to be kinds of jurisdiction.
Spicy.
In U.S. law. How you know...
Exactly what you came here to hear. You know, you've missed us for a few weeks. Now you get to hear about different kinds of jurisdiction.
Yeah, you know, where you can sue, who you can sue, and what kind of court, and whether it's true that only an admiralty court can fly a flag with a gold trim, and you can only be court-martialed once. So, for
is that the
King
Dale
of the
Gribble
fans,
theory of,
yes.
of jurisdiction, right?
So that's going to be our sort of our big topic, quote unquote. But we're also going to be reviewing a couple recent Supreme Court decisions or actions, or whatever you want to call them. But with that said, I think we should hop into it.
Look at these three words written larger than the rest, with a special pride never written before or since. Tall words proudly saying, "We the people."
All right, just to let you guys know, we're trying out a new thing. We're going to be announcing our topics ahead of time. So we're going to have a series coming up on Alexander's favorite
one of history's
philosopher.
Most interesting and original, I don't know. One of history's weirdest and dumbest philosophers, none other than Jeremy Bentham.
Yeah, we'll tell you a little bit more about that later in the episode as well, but that's something to look forward to. A man who has outsized influence on the political landscape.
On a variety of fields. He's really a polymath, that guy.
So
good at so many things, critiquing the Declaration of Independence. And he was really the life of the party. I mean, he knew his friends were going to miss him when he died, so he said, well, so that you won't miss me, why don't you just preserve my body in formaldehyde, and then it can sit around with my friends after I'm dead. So that's our next three episodes are going to be on Mr. Bentham.
Yeah, on a variety of subjects. But yeah, that's something to look forward to.
And then after that, we will be taking our long-promised dive into AI and whether or not it can be helpful in the legal profession.
Yeah.
I've been trying it out.
Yes, I guess spoilers, mild spoilers. Sometimes yes. Oftentimes
usually no.
Yeah.
Usually no.
I'm trying to think of the best balance. To say
I don't think I'm being replaced anytime soon. Let me put it that way.
I think that's accurate. Anyway, something to look forward to.
And with that introduction, let's take a look at one of the first cases for our docket today. Item number one is Arizona v. Mayorkas. We practiced the pronunciation of this word before we started.
Yeah. We're not 100% on this one. It's like the word mayor and then KAS. So
and then you added an R in the notes, and that's still what I have in my
spelled
notes.
It wrong.
That's not.
I spelled it wrong.
You've been in Britain too long, David.
All right, we talked about how that doesn't make sense, but
they have those R's sometimes, in words that have an A sound. They remove most of the R's, then they add in a couple.
Have we talked about how that was my experience with certain forms of the Boston accent as a child in Massachusetts? How
I don't think we have.
It's sort of like the suburban rim of the Boston accent. You start to get back some of those R's that they're dropping. So I had a teacher in like first or second grade who would say, ka and stuff like that. But then she'd ask us if we were excited to, yeah. But then she'd ask us if we were excited to eat pizza, or if we had any ideas.
So you
about
can eat pizza at Harvard in the yard.
In your
right?
car, yeah.
Yeah, you got to have it in the yard and eat pizza.
Yeah. Mm-hmm.
Cool. That's great. Wonderful.
Anyway, that's really neither here nor there. Well, so Arizona v. I'm going to go with Mayorkas.
Mayorkas. Let's go with that.
What happened here?
Background here.
Yeah.
A couple of years ago, for those who have not been paying much attention, we had a pandemic. Right? So
yeah, you may have heard.
Yeah, or at least they claimed it was a pandemic. I don't know. That's
spicy.
That's up in the air. They said that there was this new variant of a coronavirus, called it the novel coronavirus, came around, affected everybody. A bunch of people died. May have heard about it. Anyway, as a result of this pandemic, different jurisdictions proliferated various kinds of laws, mandates, regulations, things of dubious legality in many
Mandates,
instances.
Orders.
What's that, David?
Mandates, orders,
different
dictates.
kinds of things. Some people did it in a little bit more kosher format than others. But the one we're looking at here is a Title 42 order restricting immigration at the border as a result of the pandemic. So, it's if you were to divide COVID-19 regulations along partisan lines, I'm not saying you ought to do that, but if you were to do so, I think most people would agree that the majority of these regulations, mandates, orders, laws, etc., skewed left, right? It was the left wingers that didn't want to get sick.
Be that as it may, that's really not relevant to the legal ruling here, which was that you had a group of states led by Republican attorney generals,
attorneys general,
in order to. Fair point. Yes, thank you.
It's like Spider-Man. If you have more than one Spider-Man, it's Spiders Man.
Spiders Man. Yeah, interesting. I'm not sure I agree with that one.
Batsman. That's a term already.
Yeah, that actually is a word.
Yeah.
But anyway,
not in our country, but in yours.
A group of states seeking to have the Biden administration enjoined to continue enforcing this policy, and the Supreme Court basically threw out the case because at this point it's moot. The national state of emergency ended, I think, last month, if I remember correctly.
Yeah.
So the basis of the order no longer applies. That's what actually sort of happened. If you were looking just sort of on paper, what happened at the Supreme Court with regard to the Title 42 COVID measure, that's
nothing happened.
Basically, yes.
But when nothing happens, it's a great opportunity to pontificate. So who's pontificating here but none other than one of our very favorite justices, Neil Gorsuch. And what does he have to say, David?
So as you'll tell from the beginning, this is not the first thing he said. This is after a long sort of rehearsal of all the legal background here.
He didn't like COVID restrictions.
No, and that will come out as well. So and here I quote, "I recite all this tortured procedural history, not because I think this court's decision today is wrong."
And remind us what the decision was.
To dismiss the case brought by the states to continue enforcement of this COVID measure.
Right.
It became moot with the end of the national emergency.
All right. So the states are trying to make him keep doing.
Yeah.
Yeah. And they're deciding not to do that.
Right. He said, "Nearly 5 months ago, I argued that the court erred when it granted expedited review and issued a stay. As I explained at the time, I do not discount the state's concerns about what is happening at the border. But, quote, the current border crisis is not a COVID crisis."
And I agree with that.
Yeah.
It's for whatever harm rescinding Title 42 will cause. Our border crisis is not a COVID crisis. It's its own issue.
And the court took a serious misstep when it effectively allowed non-parties to this case to manipulate our docket to prolong an emergency decree designed for one crisis in order to address an entirely different one.
So obviously, of course, referring to the fact that originally this was a dispute between Arizona and the federal government, and then a bunch of other states, many of whom are not even on the border, are arguing in favor of continued enforcement. Obviously, if you're not on the border, there's no harm to you that occurs here. I mean, debatably, because we do have free passage in the U.S., but probably shouldn't be a party.
Yeah. One of the states is Alaska, and I'm guessing probably not a lot of people are getting over the border and then immediately bolting for Alaska.
Well, they might be coming over. They might be coming from Russia, David.
I'm not sure we had a lot of people swimming the Bering Strait.
They might have been coming from Canada, David.
They could be coming from Canada, yes.
Those are the ones you really got to keep out.
Yeah. We can't allow them to bring their weird bacon into this country.
And they'll get maple syrup all over all of our American dollar bills, and they'll stick together, and you just can't have that.
They might pass some of their quarters as our quarters when the exchange rate is not exactly 1-to-1.
Yeah, that happens occasionally. That's a forgery. That's passing off a document of apparent legal significance as an authentic one when it is not.
Yeah, and the impact on the economy, you're being defrauded of, I think, roughly like 0.8 cents every time that happens. But
it's an act of war.
Uh-huh. Anyway, he goes on. Since March 2020, we may have experienced the greatest intrusions on civil liberties in the peacetime history of this country. I'm eliding a few things here. I'm skipping around a bit. But
that's a big.
Yeah.
We may have experienced the greatest intrusions on civil liberties in the peacetime history of this country.
Doubtless, many lessons can be learned from this chapter in our history, and hopefully serious efforts will be made to study it. As a side note, I'm sure they will. I think 2020 will go down as a significant year in the history books when all is said and done. One lesson might be this. Fear and the desire for safety are powerful forces. They can lead to a clamor for action, almost any action, as long as someone does something to address a perceived threat. A leader or an expert who claims he can fix everything, if only we do exactly as he says, can prove an irresistible force. We do not need to confront a bayonet. We need only a nudge before we willingly abandon the nicety of requiring laws to be adopted by our legislative representatives and accept rule by decree.
Yeah. And that to me just very succinctly puts exactly what we've experienced for the past 3 years. And, it's put in terms that I think are very accurate, but evocative of, the kind of situation that arose in the Soviet Union or in Russia, pre-Soviet Union. We talked about that in this podcast earlier this year. It's evocative of the collapse of the Weimar Republic into the Third Reich. It's the reason why, and we've said this a lot, so I won't belabor it too much, but the reason why you have procedure that you have to go through, the reason why you have to have lots of steps before you can make a law, the reason why you have due process requirements if someone is dragged before the court, is because a lot of the things the law pertains to are very emotional subjects. And when you have something that evokes people's very strong emotions, something like a pandemic that produces, great fear in people, or even something like, when you have really heinous crimes that occur. You could think of myriad examples of things that are evocative of strong emotions to people. The tendency, the inclination is always going to be to ignore the rule of law. But really, it's just the opposite. Those instances are the ones in which the rule of law becomes most important, and it becomes most critical that you respect the rule of law. Because otherwise, you're going to replace sound reasonings from clear minds that were made when we were not in the heat of passion with decisions made in the heat of passion. And I think as any human being who has had emotions can attest, you don't make good decisions when you're in the heat of passion.
No. Yeah. It's always easy to believe you respect people's rights when no one has offended you. And it's always easy to believe that you care about the process when it's easy to follow the process.
Right.
But
yeah. And I think that's the real, it's a lesson we should have learned 1,000 times before the COVID-19 pandemic, but certainly after the COVID-19 pandemic, you don't just throw out the rule of law because of an emergency. In fact, the emergency makes following the rule of law all that much more necessary. And this is, we covered this in our series on the Roman Republic and its collapse into empire. It was exactly this flaw because, remember, their constitution actually had provision for emergencies where you could suspend the rule of law. And it was exactly that flaw that became exploited.
Yep.
Emergency measures never a great thing. Rule of law needs to apply all the time. That's why we're the Lex Rex Institute, because the law is king. It is our only king. It is supreme over the actions of men. Okay, so enough of that one. Next, we're moving on to National Pork Producers Council. Oh, we're supposed to do our transition.
Thank you.
All right, moving on to National Pork Producers v. Ross. So this is one where this is actually a case the Lex Rex Institute was trying to get. One of the reasons we were founded was we wanted to bring exactly this challenge. They lost. The people who did bring it lost. Lex Rex was not involved. Not saying we would have done better, but I'm saying we could have.
Anyway, this
they lost 9-0 too, basically.
Yeah, it was kind of a bloodbath ultimately. But so let's talk a bit about the background here. It's had to do.
So pigs are an animal. right?
That's true. A mammal.
When they're walking around going oink oink, they call them pigs. When you kill them and put them on the table, it's called pork.
That's right.
That's because of the Norman conquest that happens. That's why the name changes. But those are the same thing, believe it or not. And so a few years back, California had a proposition for better treatment of pigs.
I think we may have actually talked about this one previously when this was in earlier stages. But basically what it called for was larger pens for pigs, at least under certain conditions.
Oh, that sounds pretty reasonable.
I mean, that certainly seemed to be the opinion of the California voters, but obviously,
I mean, they should have space to walk around, right?
Yeah, well, that's what the California voters thought, certainly, but obviously more space means fewer pigs in a given area, means, less efficiency in terms of the actual pork production, means higher prices.
It's a difficult thing to balance. It's
we're not concerned at this point about the rights or wrongs or the goods or bads of various kinds of animal welfare legislation.
Yeah,
that's not the issue.
I think we all agree animals should be treated nicely. I think we disagree on two things: whether or not that ought to be mandated by law, and then secondly, whether or not such laws can be imposed by a state in a fashion where they impose burdens upon interstate commerce.
Right, and that's the key here, is that it didn't pertain exclusively to the practices of farmers in California. That would be one thing. If they said in the state of California, if you're raising pigs, you need to do X, Y, or Z.
It was all pork sold in the state of California, which, because these new methods are so much more expensive, or at least here's the argument, because those methods are so much more expensive, effectively what that does is it prohibits pork produced outside of California from being sold within California, because no other state is going to meet the new requirements. It's going to make pork too doggone expensive. So the only pork that will be available on shelves in California will be pork that is raised in California.
Yeah, which, and I think we may have discussed this last time as well. California does not have an especially robust pork industry. There's plenty of other agricultural activities in California, but most pork is coming from outside the state.
Right.
That's also part of the background here.
And as we talked about the Commerce Clause a lot, but just kind of a brief recap, what Interstate Commerce Clause does is it allows only Congress, so Congress and only Congress, to regulate anything classified as commerce between the states. Now, we've talked a lot about how both the definition of commerce and the definition of between and the definition of states
pretty much expanded. Every element
have vastly expanded over the past 240 years or so. To the point
pick a random episode we've done in the past, and we probably talk about the Commerce Clause.
I'm not even going to say we're going to put links here because it's too many of them. Anyway, vastly expanded. But another component of Congress's ability to regulate commerce between the states is that only Congress can regulate commerce between the states, which means that states cannot regulate commerce between them and other states. So how do you recognize if a law is commerce between states, if it's regulating commerce between states? Well, typically, it's whether or not it imposes an undue burden on the ability of out-of-state actors to act in a market within that state.
Yeah, and that's the basis of the challenge that was raised here. This, National Pork Producers Council. I haven't looked into exactly who's a part of this, but presumably it's a number of, pork producers from throughout the country, most of whom are going to be non-Californian. And essentially they argued what California is doing here, because California is also such a large market, it's going to inevitably affect the way they do business. You really can't avoid being impacted by this regulation.
And that's actually where I think they went wrong with the argument here. They argued that because California is so big, out-of-state pork producers will be forced to comply with California's new requirement. And that's the way in which California regulated out-of-state commerce. I don't agree with that. I think California is so big, we'll probably just start raising pigs on our own. There's lots of people here, and the effect will be that you cannot buy pork that comes from out of state because it's never going to be economically feasible for out of state actors to produce pork for California consumption, which would also be a regulation on interstate commerce because it's an effective prohibition of out-of-state pork from being sold.
Yeah.
I think that would be a much easier case to make because the only evidence you have to show in that case is the increased cost of producing pork.
Mm-hmm.
You know, the other way, it's like we're arguing over what percentage of pork actually goes to California. I think it's a losing case that way. So,
yeah. Well, and as we've mentioned, they did lose ultimately.
Yeah, because it turns out like 0% of the pork goes to California because it's too dang expensive.
Yeah. What I think is interesting here, though, is that despite, as we mentioned, you know, I forget if it was 8 justices or maybe even all 9 justices ruled against.
Some of them, I think, were technically dissenting, but they concurred in judgment. So
exactly, we ended up with, you know, the main opinion being penned again by Neil Gorsuch, but with like 4 separate concurrences in part. So like everyone wanted to say their bit about this.
And let's play out why that is. Okay.
Mm-hmm.
Now, we obviously caution against reading the court as liberal or conservative, right? But
yeah,
they definitely have judicial philosophies.
Yes.
So I'm going to state a few principles these people hold. People with one sort of judicial philosophy, we'll call it originalism. Those people tend to dislike overreach of the Commerce Clause.
Yeah.
They also tend to dislike regulations. Mm-hmm. They also, even more, tend to dislike regulations that they feel are a bunch of hippie, you know, tree-hugging BS.
To put a fine point on it, yes.
Yeah, we're going to play up the stereotypes there. Let's see. Any other factors in play? Those are about all I can think of for that side of the spectrum.
Yeah, I think that pretty much sums it up.
Yeah. Mm-hmm. On the other side of the spectrum, we have the very people who have expanded the Commerce Clause to its ungodly and unconscionable size that it is now today. But, you know, those folks just love regulations. They'll regulate the heck out of anything, and especially if it has to do with cute little animals.
Yep.
You know, it's somebody with that particular judicial persuasion. We've roasted him on here before. Once argued that trees ought to be able to be litigants in court.
Yeah. Someone must speak for the trees.
Yeah. No, the trees must speak for themselves and have a lawyer that's, you know, representing them. They should be able to be litigants. You should be able to have like this grove of elm trees v. United States.
Mm-hmm. Yeah, represented by Lorax Esquire.
Yeah, so we know they like nature.
Mm-hmm.
So, what are these folks to do when faced with this case that is trying to overturn a law that protects animals, but to do so would require you to rein in the Commerce Clause? And we can't have that. You know, the judicial activists can't have that. That's the main, I've talked about before, that's the number one tool Congress uses to squeeze every ounce of life out of this country. And the liberals want, I'm sorry, not the liberals, the judicial activists need that. Like, that's their lifeblood, is doing that. So what are we to do here, David?
Mm-hmm. Well, you get some interesting balancing acts, I think. So I guess we should start with the opinion by Justice Gorsuch.
By the way, I love it when cases like this come down the pike. You know, when somebody's judicial philosophy cuts against their political philosophy, it's great because you know, you just stress certain parts of the argument, you play up certain parts of the argument, you can get swing votes you really don't expect. I don't think the litigants did that very well in this case. You know, I'm a bit of an optimist here, but I can demonstrate this from court history. Most justices will side with their judicial philosophy way over and above their political philosophy. So the fact that it's a regulation having to do with animal welfare, I think, is going to end up being less important here than the Commerce Clause issues. So let's take a look.
Anyway, I think we should start with Justice Gorsuch, who, you know, he wrote the lead opinion here that had all these partial concurrences.
He tends to be good at that. You know, when the politics cut against the legal philosophy, and that's kind of why I like him. He's a really good exponent of these sound legal principles, even when they go against his politics.
Yeah. and he's going to be one of these guys who's not a big fan of, I guess we're calling it the expanded Commerce Clause. He's going to be concerned about Congress using interstate commerce powers in various ways. He's going to be on that end of things, but I think the balancing act he has going, in his opinion, is that he's also trying to preserve the rights of the individual states to make their own internal policy choices.
There's the federalism issue too that we didn't even touch on. Which also is going to cut pretty much the same way. The people who are going to be not going to like over-expansive Commerce Clause are also going to be pro-federalism. So
right, and in that case, I think that's what made the difference, certainly in his reasoning, as given in the opinion. But basically, and so what the court officially ruled was that the appellants had failed to state a claim, basically. So, what they were alleging happened to them didn't actually violate law. Is basically the form that's ruling came.
Yeah, it's failure to assert a claim upon which relief may be granted, which means that you haven't even alleged that a law has been broken, even if all your facts are true.
Right. And so the reason he says that's the case is fundamentally that Proposition 12, that pork regulation in California, doesn't, as he puts it, discriminate against out-of-state commerce because it applies equally well to in-state producers. So the idea is, it doesn't actually devolve differently. And he cites some past cases on this issue where the issue had been things like states setting minimum prices for beer. So if you're an out-of-state producer, you can make.
What about the watermelon inspection one, though? The Arizona, I forget the name, but the Arizona watermelon inspection, because that seems exactly on point here. Full disclosure, I've not read this opinion yet, so I'm just interrogating David.
he talks about Pike v. Bruce Church, which that's that case, and he says, and this is I'm not sure I'm on board with everything he's got to say here, but he says that they overstate the extent to which Pike and its progeny, so cases following the reasoning in Pike.
But there's a lot that follow the reasoning, and that's kind of been considered controlling precedent here.
Yeah, but anyway, he says that they overstate the extent to which Pike and his progeny depart from the anti-discrimination rule. He said later, a law's practical effects may also disclose the presence of a discriminatory purpose. So he's saying it's still fundamentally this anti-discrimination principle, and Pike was just sort of
that seems like such a fact-weighing thing, though. Whether or not the practical circumstances evidence that, well, the real purpose of this law was to discriminate against out-of-state commerce. Because if discriminating against out-of-state commerce is illegal, states aren't going to pass laws that facially do that. They're going to pass laws where that's the practical effect, right? Which is what Pike said happened.
Yeah, it'd be like,
it's basically, so in that one is all the watermelons had to have a stamp basically saying they were certified by some kind of Arizona board of watermelon certification, if I recall correctly. And they said that it's basically impossible out-of-state watermelons can ever get that.
Yeah, it was, if I recall correctly, it was more specifically something that watermelons grown in state also had to be packed in state in order to display the grown in state sticker, something like that.
Right.
And, it was a case of a guy who grew watermelons right over the border from another state, and it was cheaper for him to have them packed over there. At any rate, I agree with you. I think that, I'm not fully convinced by this reasoning. I think that's sort of
if they'd looked at the facts, done full evidentiary hearings and concluded that there is no factual nexus here showing that there was a discriminatory intent behind the California law where there was in Pike, that would make sense to me. But on 12b6 motion, that seems odd.
Yeah. But
because that's failure to state a claim. No, we've alleged that this law is discriminatory and that it was intended to discriminate.
I think so. Let me find this.
Is it basically just like, well, I believe there's a lot of bleeding heart animal activists in California, so I don't think this is plausible. I think the real reason they did it is to protect the animals, In
a sense, yes. He basically, one of the arguments he makes is that we're dealing with incommensurable things here. You can't actually compare the benefit that California sees in prevention of maltreatment of animals versus the dollars and cents. Those are things you cannot actually weigh against each other. There's no means to do that.
Except
so
that you don't, without hearing evidence, you don't know that California sees any value in taking care of the animals. So I don't know how you win this on a 12b6.
Yeah. And clearly, as we'll see, even people who agreed with the judgment did not agree very much at all in some instances with this reasoning.
I will say that there's a lot of case history and a lot of legal history showing that animal welfare is a priority in the law. That is something the law cares about, something it countenances frequently. Whereas made in state, sticker saying made in state, the benefit of that seems to be buying things that were made in your state, which is as such discriminatory. So I'll give them that much. That's fair. It does go a step beyond Pike on that.
Yeah. So anyway, let's take a look next at Justice Sotomayor, who, as I think everybody else who wrote anything on this case, submitted a partial concurrence. And she says, I vote to affirm the judgment because petitioners fail to allege a substantial burden on interstate commerce as required by Pike, not because of any fundamental reworking of that doctrine. And then
that's what Gorsuch said too. Gorsuch said he's not reworking Pike.
That is what she meant there, was that the petitioners have not reworked Pike.
Oh, I see.
The wording got a little lost there in excerpting it, but that's what she was getting at. Anyway, a bit later she writes, Justice Gorsuch, for a plurality, concludes that petitioner's Pike claim fails because courts are incapable of balancing economic burdens against non-economic benefits. I do not join that portion of Justice Gorsuch's opinion. And here, I think we can see, again, if I kind
of like that as a ruling going forward. What she's stating as Gorsuch's ruling, but that certainly does narrow Pike.
Yeah. And I think, again,
because that's true. Pike was comparing one economic benefit against another economic benefit. Here we're looking at a non-economic one against an economic one. And did he actually say that you can't balance the two? That's if he did, kudos to that guy. That's what the court should have been saying for decades.
I don't remember if he said it absolutely, or if he just said it's very difficult and we shouldn't in general. I forget exactly how he said it. But
he, like us, is not a big fan of these balancing tests because they balance unlike things.
Right. And you can see here, Justice Sotomayor, has a very different judicial philosophy in general than Justice Gorsuch does. And
she likes the balancing test.
Yeah, you can see her preserving the room to do exactly that, to say, some.
But I just want to say that $100,000 is worth less than the ability of this woman to get an abortion.
Right. Or
more potentially. No, that's really the more activist, the left-leaning wing of the court would have that be the difference of opinion between justices. It's just that they value these things differently. Right. Whereas an originalist, a textualist, would say that's an absurd way for judges to make decisions. There's no certainty in that. There's no predictability in the future. We shouldn't make decisions based on personal valuation of things.
Right.
I tend to lean that way.
Yeah, I think I can safely say I agree with that. Justice Barrett, who, not quite as consistent, I would say, as Justice Gorsuch on these sorts of issues, but we're swinging back in that direction. However, she says, I agree with Justice Gorsuch that the benefits and burdens of Proposition 12 are incommensurable. California's interest in eliminating...
Incommensurable, good, not just incommensurate, yeah.
Yeah. California's interest in eliminating allegedly inhumane products from its markets cannot be weighed on a scale opposite dollars and cents, at least not without second-guessing the moral judgments of California voters or making the kinds of policy decisions reserved for politicians. I'm eliding a little bit, but basically she says, but if the burdens and benefits were capable of judicial balancing, I would permit petitioners to proceed. So preserving room for some kinds of balancing tests, but seemingly not of this kind.
Yeah. Leaving things open in the future.
Yeah.
Yeah.
And
we can do balancing tests if they're appropriate. They're just not here. Where it sounds like, from what you read, Gorsuch did not absolutize it anywhere near to the degree that they're suggesting. I don't know that he said economic and non-economic values are never balanceable.
I also read this a little while ago. I don't remember exactly how far he pressed that principle. I don't think it was never, but certainly, cautioning doing that. Justice Roberts also,
I would say never.
Yeah. I think that certainly has some logical consistency to it.
But again, judicial restraint, you don't go that far if the case doesn't mandate that you go that far. So you rule on the facts before you. You say that you can't balance these harms.
Right.
You don't need to say in every case. In fact, you shouldn't.
Yeah. Justice Roberts filed basically just to say he thought that there were some procedural defects and that the case should have been remanded to begin with. And then finally, Justice Kavanaugh.
That sounds like him.
Yeah.
Thank you,
Justice
John.
Kavanaugh. Justice Kavanaugh said, among other things, and this one I didn't quote anything directly, I'm summarizing, but basically he said the argument you said you think that they made a mistake by even introducing.
Yeah.
Given the market size of California and the fact that they don't produce their own pork, this was de facto always going to be regulating nationwide pork production. And he said he wasn't sure, but he thought there may be other constitutional implications to Prop 12 as well.
I don't like that. That's my least favorite of the opinions that we've come across.
You'll note, other than the Roberts one, it's the one that I spent the least amount of attention on.
I hate that. Like that shows the bias of the fact that most of these justices are all from the eastern half of the United States. They're just like, well, look at the West. Nobody lives out there except for in California, which is huge. So it just dominates everything else out in the West. No, that isn't how it works. California is actually pretty isolated from most of the West. We have our own oil refineries here. We don't refine it in Texas the way the rest of the country does. It has to be imported here. I mean, the reason why oil gas is always way more money in California isn't just because of our stupid environmental regulations. It's because it's a separate market entirely.
Yeah.
Our freeways don't really connect to the rest of the West. They're kind of just independent in California. We're kind of our own thing. Like, I don't think that we affect the market throughout the country as much as they keep insisting we do.
Yeah. Well, and I was actually surprised to see the figures where I think it ended up being that California was something like 12% of the nationwide pork market, which is actually lower than a proportional rate would be.
Right.
So at any rate, I also feel like his entry into the ledger was basically just saying, here's the way I would argue this.
Yeah. I mean, that's worse. That's dumb. I don't like that at all.
Anyway.
Bad opinion.
So that's what happened with Pork Producers v. Ross, Pork Producers Councils v. Ross. As you mentioned, this was a case that we were tracking with some interest. It didn't quite go the way it might have, and we do think that there's a good bit of room to revise some of the jurisprudence on the Commerce Clause in the future, let's say.
Yeah, and it sounds like Gorsuch basically did that. He walked back the dormant Commerce Clause a little bit. Mm-hmm. Which is too bad because that's the part of the Commerce Clause that protects us from some of the draconian rules. But walking back Commerce Clause is a good thing. So we'll call that. That's kind of why we wanted the case, is because if you win, you win, and if you lose, you win, because you either walk. I mean, assuming you stress the issues properly, and they didn't quite do it here, but assuming you stress the issues properly, you either get a ruling that restricts the ability of states to impose economic regulations, which is good. I consider that a win. Or you get a loss, which walks back the Commerce Clause, assuming you frame the issues right.
Yeah.
So we walked back the Commerce Clause a little bit. That's good.
Mm-hmm. Anyway, that's all I've got to say on this one. I don't know if you have any further comments, but
yep, that's about it.
All
right. So now for the topic everyone's been waiting for.
Mm-hmm.
Jurisdiction.
Diction. I felt very dramatic there. I wanted to do the echo.
Yeah, I appreciate that.
Yeah. So jurisdiction. First of all, I guess, what is jurisdiction? Can you give us a concise definition? See if there's anything maybe from one of your textbooks in law school that you could give us like a...
If we pause it and wait for me to do that. So this is from Black's Law Dictionary. It's kind of the standard dictionary when it comes to law, and it defines jurisdiction as a government's general power to exercise authority over all persons and things within its territory, or a state's power to create interests that will be recognized under common law principles as valid in other states, or a court's power to decide a case or issue a decree. Yeah, and then it kind of gives a bunch of different sorts of jurisdiction.
All right. I think we're more or less talking about definition 3 there on this episode.
Authority.
Yeah.
That's what jurisdiction is. Authority to make and impose law.
Yeah. And so...
Or even just authority to impose, really. Not even make.
Yeah. So, I think I'm confident enough in my Latin, which is very limited, but to say that if we were going to sort of Anglo-Saxon that word up a bit, we talked about the Norman Revolution earlier, changing pig to pork. I think if we were going to change jurisdiction into something a little more Anglo-Saxon, it'd be like saying law, basically.
Yeah, basically, it's because it's juris, which is law,
Mm-hmm.
and dictio, I think, or something like that.
Something along those lines, yeah.
Yeah, to say or declare.
Yeah.
So it's literally person who can declare law, right? So if you have jurisdiction, you're the law sayer.
Right.
So who's the law sayer in different circumstances?
Yeah, and that's the tricky part, because we don't have just one. There's not just one guy who says what all the laws are.
Yep.
We have many.
The law sayer in different circumstances.
Right. And on a sort of broad category.
By the way, you didn't know you'd be getting the alligator alley.
Yeah, that's a bonus segment in here. Yeah, fair point. I forgot about that. We haven't done it in a while.
Yeah, so you get a bonus alligator alley.
Anyway, I'm gonna be relying on you for a lot of the heavy lifting here, because
good. I didn't do any prep for this episode. I didn't even remember the name of Pike. It's a case I rely on like weekly, and it's not.
But critically, you are an actual attorney and have been to law school. But I'm confident in saying this.
True, I'm the law sayer here.
There are at least 2 big categories of jurisdiction in American law, maybe more than 2. But
you ask Black's Law Dictionary. Let's see how many different kinds there are.
I'm sure that's going to give you a lot.
Oh yeah, it gives a lot. Agency jurisdiction, ancillary jurisdiction, anomalous jurisdiction. That's a stupid one. I shouldn't have that. Appellate jurisdiction,
good,
arising in jurisdiction, assistant jurisdiction, concurrent jurisdiction, complete jurisdiction, common law jurisdiction,
consent jurisdiction, contentious jurisdiction, continuing jurisdiction, coordinate jurisdiction, criminal jurisdiction, default jurisdiction, delinquency jurisdiction, diversity jurisdiction, emergency jurisdiction, equity jurisdiction, exclusive jurisdiction, extraterritorial jurisdiction, federal question jurisdiction, foreign jurisdiction, general personal jurisdiction, home state jurisdiction, in personam jurisdiction, in rem jurisdiction, international jurisdiction, judicial jurisdiction in personam. That's the same thing as personal jurisdiction, loci jurisdiction of the person, same thing as personal jurisdiction over the person, also same thing as personal jurisdiction quasi in rem jurisdiction, ration materia, jurisdiction rational person, same thing as personal jurisdiction ration temporis, legislative jurisdiction, limited jurisdiction, long-arm jurisdiction, original jurisdiction, overlapping jurisdiction, pendant party jurisdiction.
Okay.
Personal jurisdiction, plenary jurisdiction, primary. I'm almost done. Probate jurisdiction, prorogated jurisdiction, quasi in rem jurisdiction. I thought we already had that.
Yeah, I was gonna say I think we did already have that one.
Significant connection jurisdiction, spatial jurisdiction, special jurisdiction, specific personal jurisdiction, state jurisdiction, status offense jurisdiction, subject matter jurisdiction, summary jurisdiction. Oh my gosh, temporal jurisdiction. Jurisdictional amount, jurisdictional discovery, jurisdictional fact, doctrine. Okay, now we're on to jurisdictional things. So, that's all the kinds.
You were lying when you said you were almost on that list. That was like another 12 things. Anyway,
are we gonna leave that in?
I don't think so. Maybe I'll have to see how I feel when I'm editing. Anyway, what I was gonna say,
we're gonna narrow it down to 2.
Was. These are the 2 that I know exist and are both subdividable.
Yeah, and it's we're going to talk about jurisdiction over people here rather than
Right.
jurisdiction over cases, because to have jurisdiction over a case, you first need jurisdiction over the person, right? They have to be a person that can actually bring the case. There has to be a person against whom that court can exercise authority. So if you look at those different ones that I just read or that we may have cut, most of them can boil down to three different things: jurisdiction over people,
Yep.
what we call in rem jurisdiction, and then different kinds of court jurisdiction over case and controversies. We're going to take those out of the mix for now. We're going to look just at in person and in rem.
Yeah. So in person, I'm pretty confident that this one is just what it sounds like. You know, you're a specific person or a legal person like a corporation that a given court has authority over in some regard.
Which is the reason why every major corporation is incorporated in Delaware.
Right.
Because they want Delaware courts to have jurisdiction over disputes for that corporation, because Delaware courts are very deferential to corporations.
Yeah. And okay, so I guess we should talk about what sorts of things have to be true of you for a court to have personal jurisdiction. You know, I think probably the most obvious and intuitive one is your
domicile.
You're a permanent resident, of a given
living with the intent
place
to remain is the definition.
Yeah. Mm-hmm. So, you know, when I'm in the States, I'm currently living in North Carolina, but you know, I've moved around a lot. But you know, when I'm home, at the very least, because I am still in the UK at the moment. You know, I could be sued in North Carolina. In fact, I could still be sued in North Carolina, but
because you do not have the intent to remain in
right.
Britain, you are not domiciled there.
Mm-hmm. But that's not the only form, if I'm not mistaken, right?
That's correct.
If I'm doing business in a given place, I believe that can be a way in which a court might have jurisdiction. Or you know, if I'm traveling somewhere and I commit a crime in that locale, that's another way that a court might have jurisdiction.
It's personal jurisdiction is what that basically means is a court's power to bring a person into its adjudicative process as a result of its power over your personal rights rather than merely your property interests or anything else about you. So if you're passing through New Mexico and you murder somebody in New Mexico, New Mexico would have in-person jurisdiction over you. They call it in personam or personal jurisdiction.
So I guess the upshot there is don't rely on the idea that, you know, you could go to a different place, commit a crime, and then they don't get you because you don't live there.
Right.
I think most people get that. I'm not sure that a lot of people are going to try that one, but don't, basically.
But there needs to be some connection between the person and that that state for there to be jurisdiction there. Like you can't if I committed a murder in California and I murdered, actually regardless of what state the person I murdered is from, but if I murdered a Californian, Delaware couldn't hold the trial.
Right. Yeah. Let alone, you know, Canada or something.
That seems really obvious. And like, we could get deeper than that, but it's going to get really boring.
Yeah, I think this one's the most intuitive.
David?
Because some of the forms of jurisdiction get a little more nuanced, I think, than personal.
Yeah, they do, but they get really boring when you start doing that. Like literally, you learn that all in civil procedure your first semester in law school, and it's the most boring class you take. If you can stay awake through that class, you'll pass law school.
All right, so I guess maybe people listening can consider this like a test case. If you've been thinking about going to law school, see how you respond to this one.
I'm going to try not to. You know, we're not going to do like international shoe doctrine, and
I have never.
I'm having flashbacks just thinking about it.
But anyway, so that's personal jurisdiction. Let's talk a bit about jurisdiction in rem.
Yeah.
So what does that
That's
mean?
if you're asleep and you've entered the rapid eye movement section of sleep.
I don't think that's quite right.
It's only the court of dreamland can hold you to account for what you do.
You know, I am confident enough, again, in my Latin to say that is not what that means.
Oh.
That means jurisdiction in a thing.
That's right, David. Yeah, so it's still jurisdiction over a person, but rather than being based upon personal aspects of that person, like the exercise of personal rights or things they're doing as a person, it's based upon that person's property interests within a given jurisdiction. So if you own a home in California, even though you've never been there, and somebody
you bought it,
trespasses on your home, and then it turns out that there were a bunch of bear traps all over, and they step on one and cuts their leg off, they can haul you into court in California because there's in rem jurisdiction over you.
Yeah.
How deep do we want to get for like what counts as in rem and what doesn't?
How briefly could you do that?
I mean, quasi in rem comes up a lot.
Okay, so what does that mean?
That has to do with the person's interest in property located within a territory.
Okay, so meaning like, if I'm part owner of I have a stake in physical property somewhere.
Yeah, you wouldn't have to be a part owner, but some stake. Yeah.
Okay. Cool.
There's rules for when this stuff applies, but I'd just be kind of reciting like 1,000 rules. I don't.
Right. I think that's what we want to emphasize more than all of the granular details, is just getting people to recognize that, this gets more complicated than you might think it does.
And we could tease that out. We could give scenarios where it's like everybody's on an airplane. Mm-hmm. The company that owns the airplane is incorporated in Delaware. Its principal place of business is located in Washington State. The flight left LAX airport, Los Angeles, California. There were people from 8 different states on this flight. The flight was going cross country. It was going to land in Washington, D.C. While flying across country, a Stinger missile launched from the state of Nebraska hits the airplane and it crashes in Missouri.
Yeah. Obviously,
where can the family sue?
Right. And, I think this is one of those things where I think people who have never either been involved in sort of nitty gritty legal stuff or haven't, looked into it very particularly, but it may surprise them to hear this. But very often the first step in any kind of legal proceeding is just figuring out where can actually hear it.
You got to put it in your complaint. I mean, that's
right.
A section you have to have. Why does this court have jurisdiction over this case in controversy? Yeah. And it's, if you, in an answer, so if you're a defendant answering a complaint, you don't even have to answer if you're disputing jurisdiction. You can say, I don't have to, you don't own me. You're not the boss of me. Yeah. And you can just say that. Then the court will hear your jurisdictional dispute before it gets to anything else having to do with the case.
Yeah. Did you ever see the video of the guy at like a New York bakery who gets really upset about something and tells somebody, you're not, I think it's, you're not my boss or God or my father. You can't tell me what to do. That's basically what that looks like. You don't have any of these kinds of jurisdiction over me.
Shut your mouth. You're not God or my father or my boss.
Yeah, well, those are all various kinds of jurisdiction. Yeah, and that's the important thing to remember too, is there's never going to be only one judicial power that has jurisdiction over you at any given time.
Right.
If you live in the United States, bare minimum, there are 2. If you live in a totally unincorporated area where you're not part of a county, you're still going to be part of a state.
Yeah.
Or at the very least, you're going to be part of a territory. Mm-hmm. So you're at the very least going to have the state authority, state court that can drag you in, and federal court that can drag you in.
Right. Yeah.
Even if you own nothing, have never spoken to anyone, have never met another human being.
Yeah, you were, you emerged from a pod somewhere in the wilds of Montana or something.
Right. Yeah, except for, there are exceptions here, actually. I guess there's some national, well, because the federal government has exclusive jurisdiction over national parks.
That's true.
So
mm-hmm.
It's really hard to make absolute statements about this.
That's another thing we want to draw out here. Yeah, there's always something weird. There's always some wrinkle that you can find somewhere in almost any kind of.
And that's why you want a creative lawyer.
Yeah.
And it's like, that's what's fun is when I like, oh, here's a really weird thing here. We can dispute jurisdiction. Yeah, we'll just do that. We're not even going to respond.
Yeah.
I actually had a client where we got a motion to dismiss based on lack of jurisdiction, which is common. You get that a lot. And she's asking me, does this mean they're afraid? Are they afraid of our legal arguments? They don't want to get to the merits of the case. And I'm like, no. If they can avoid getting to the merits, they will. This is easier.
Yeah.
This is a way easier. Of course they're going to do this.
Yeah.
They're
All
wrong.
right.
Like, the court does have jurisdiction, but
yeah. But, it's probably going to be the most cost-effective way for them to win, if they could win on that anyway for their client.
yeah.
So
Otherwise, they just wasted the money on it. It's less cost-effective. But
yeah. All right. Anyway, there are a few other, not quite as granular as that list you were reading earlier.
Actually,
which, again,
here's an absolute statement you can make. Anywhere in the United States, whether it's a territory, whether it's a national park, whether it's not any of those things, if it is in the United States, you are under the jurisdiction of the United States Constitution.
Yeah.
Full stop. There is nowhere in this country the Constitution does not apply. And that's why we hold the Constitution in such high regard, because the buck literally does stop there. Whatever else may be true, everyone in the United States is subject to the Constitution, because the United States is defined by the Constitution. That's what makes us a legal entity.
right.
And another important one to recognize, another jurisdiction everybody's under, was the same one that Thomas Jefferson recognized in the Declaration of Independence. The basis for the United States asserting any claim of unlawfulness against Great Britain when we I want to say filed, but when we sent our Declaration of Independence, was that the laws of nature and nature's God had jurisdiction over all men.
Yeah.
So you would always be subject to both of those, wherever you are in the United States, wherever you are in the world when it comes to nature and nature's God. Yeah.
And we'll probably at some point talk specifically about natural law tradition and its relation to the U.S. system at some point. But that is, it may sound like a philosophical and sort of abstract statement, but it actually is crucial to the system of common law that we have, the idea that there is natural law.
So, there's
anyway,
that.
Side note, all of that.
It does have practical import. And David was saying we'll probably do another episode about that later. But
yeah. Like, as much as, I think we tend to hear statements like that from the Declaration of Independence as though, it's high rhetoric and it sounds nice, but it doesn't actually have practical import. That's wrong, actually.
Yeah.
Anyway,
the whole common law system doesn't work without natural law to undergird it. And that's kind of what we got in with Kagan's quotation in our last episode. Is she didn't understand how the common law system worked. She thought it was just there to prop up wrong decisions, because she doesn't understand there's a natural law undergirding it, where cases are the evidence of what is lawful. They are not, they do not create law.
Anyway, we're starting to push on our time, so I just want to run down a few other items on my list, things I found in my very thorough internet searching for kinds of jurisdiction. But not quite as granular as that list you were reading earlier, and which may or may not end up in the episode. But
you can just speed it up.
Yeah. So another kind of jurisdiction that is possible to have, subject matter jurisdiction.
Yes.
So
yeah, that's more for courts and less for you and me. But yeah, federal subject matter jurisdiction. If it's a federal question, then federal courts will have jurisdiction over that. Question is state law. The state court would have jurisdiction over that.
Yeah. And yeah, we're gonna go rapid fire here. How about appellate jurisdiction? What's that all about? Tell us about that.
Yeah. So that's if the lower. So you have a whole trial. You allege that Oscar Mayer Wiener you ate should not have had human bones in it, and that caused you harm. Yeah. And Oscar Mayer. I shouldn't say Oscar Mayer. I'm going to get sued for defamation. Whatever your case was, you didn't like the outcome. You thought it was bad.
Yeah.
You're not good. You can't just appeal that anywhere. You have to appeal it to a court that is above the court that you were talking about. In fact, we were just talking at length about appellate jurisdiction, right? Like, if you have a state court ruling on something, the court that has appellate jurisdiction over that state court, if it's a matter of state law, would be a state appellate court or a state Supreme Court.
Yeah.
Not a federal appellate court or a federal Supreme Court. Now, there are instances where you could appeal to those courts if there was also a basis for federal jurisdiction, but it wouldn't be within that court's appellate jurisdiction. It'd be within that court's original jurisdiction. This is getting too complicated. Anyway, appellate jurisdiction is important because it shows who has authority over the other court.
Yeah.
And, that you can trace that all the way up, ultimately, to the laws of nature and nature's God, which has the final appellate jurisdiction. And that's the reason why the Declaration of Independence was legitimate.
Yeah, actually, I remember. I don't remember what the exact context was. I don't remember what these statements were from, but I remember at one point you showed me a bunch of stuff people had written about why the Supreme Court should hear this kind of thing or that kind of thing, and a lot of them were basically just like, "Oh, it's an important case; they should hear it." And I remember, we talked about this at the time that appellate jurisdiction. You do have to go through stages. The Supreme Court doesn't just hear like all of the best cases, all the most important and interesting, and this has to be gotten right because it's so important.
And we have a video on how the Supreme Court decides which cases it takes. We'll link that in the description.
Yeah, and actually that's a good segue because the last thing that I had on my list was discretionary jurisdiction, which is actually a bit different than the other things we've been talking about. But that's basically what that is. The Supreme Court
it's not that they can decide they do have jurisdiction over you. It's that they decide they don't have jurisdiction over you.
Yeah.
It's not just like, they can be like, Portugal, what you doing? Not allowed to do that anymore. It's people that are already under that, subject to that court's jurisdiction. The court can decline to take cases. So, most appellate courts, if I were to appeal something, let's take a federal case. If I were to appeal a federal case, it would go to like the Ninth Circuit Court of Appeals. They don't get to say, we don't want that. Supreme Court's a little bit different. Unless something is in its original jurisdiction, which is a very limited list of things, it takes cases on what's called writ of certiorari. And it has to grant certiorari on those cases because it has discretion over whether or not it takes them.
Anyway, hopefully that wasn't too mind-numbingly boring as we feared it might be.
Which is okay, because next time we meet, we're going to be doing something much more exciting. We're actually going to be doing a 3-part series on a man who is, probably one of history's...
Yeah, a guy that you said you want the podcast to prove is the worst philosopher in history. That may be...
Did I say it that way?
Not exactly that way, but certainly something close to that. I don't remember.
Somebody who caused a lot of harm, certainly in our modern American experience.
Yeah.
There's other people who have been more far-reaching, other people who have, I don't know, they've been more dense than he is.
Anyway, it's Jeremy Bentham.
Bentham.
Yeah, some of you may recognize that name. And if you do, it's probably from history class where basically the way they
utilitarian
tend to teach,
principle comes from
they tend to teach Jeremy Bentham as seemingly the first guy who ever thought that things should be done if they're practically beneficial.
Greatest happiness to the greatest number of people is the way it's often cited.
But it gets so much weirder, so much more
spoilers, but
absurd.
we've got weird spying prisons. We have parts that we will probably need to say are not family friendly based on some of the things he writes. We've got a guy who in the middle of writing his book says, I read one of my other books and I couldn't make sense of it.
It seemed like a stupid thing I was saying. Yeah. A man who requested after he died that his body be stuffed and preserved so that his friends could take it out at parties and not miss him.
Yeah, his friends told him we'll get more into that, but I don't want to spoil too much. But he's a fun guy. Life of the party.
I think we have just enough time to do Captain Kangaroo here.
All right, gather around, folks. It's time once again for everyone's favorite segment of this podcast, where we examine eccentricities and crazy features of the law throughout the United States and throughout the world, throughout all history. Captain Kangaroo Court. So, I don't have anything planned for this, David. Do you have things planned for?
I do.
Captain Kangaroo?
And I guess this is going to be a bit of a theme because I've been quizzing you quite a lot here. I have a pop quiz for you, one that you're going to hate because it's not going to be precise at all, and the phrasing is going to frustrate you, I think.
Okay.
But I'm going to present you with 3 different things that have been referred to as the X defense. So, 3 different things.
We're doing the Twinkie defense?
Twinkie defense is first up. So can you explain
to
us
what's the Black Rage defense? We're doing that one?
No, not that one.
Okay.
But anyway, Twinkie defense is first up. So can you explain to the people what the Twinkie defense was?
I'm forgetting the details. It wasn't actually a legally significant case, but it was in the news a lot. And basically the argument was this guy ate a bunch of Twinkies and made him so angry he committed some kind of violent crime, right?
Not quite. That's basically the way that it was reported on. And maybe it'll make you happy to know that that's not at all what the defense team did.
Okay. Well, good.
Yeah, because that would be nonsense.
That'd be hard to prove. Like, you need a pretty good expert witness for that one.
Yeah.
Now, granted, if the CEO of Hostess says that Twinkies are designed to do this, done and done.
To make people temporarily, homicidally insane. Not quite. It actually was, I don't mean to make light of the case itself. It was a double murder, very serious crime. It was actually the assassination of Harvey Milk,
That's
and
right.
The mayor of San Francisco at that
right.
time, George Moscone. The media reported it as though the accused's attorneys were saying he started eating a bunch of Twinkies and it drove him insane and he committed these murders. That's not what they said. What they were doing essentially was arguing down from a murder charge to a manslaughter charge by
that's
citing,
what you do. That's the way murder defenses work. They mitigate.
Yeah. And they cited evidence, among other things, that he had been in a profoundly depressed state of mind. And one of the things they cited as evidence for this was he used to be a fanatic for his health, but he had started eating terribly, including large amounts of Twinkies. It wasn't the only thing they mentioned. They, basically said he stopped taking care of himself. He seemed to be in a profound depressive mood.
Wait, so what's the mitigating facts there?
Essentially,
that's just a motive to kill people, being depressed.
I will say I'm not sure that if I were on the jury, I would have bought this argument.
Well, I'm saying even if you buy it, I don't understand why it mitigates.
Basically, the thrust of it was he wasn't capable of premeditation. Basically, he was not.
So it's a mitigation from first degree to second degree murder, not to manslaughter.
Yeah, I think. Let me check the
standard murder. Common law murder is unlawful killing of a human being with malice aforethought, and then you ratchet that up to first degree if it's with premeditation and deliberation.
Yeah, I'm citing the infallible Wikipedia here. So again, I have no idea how exactly accurate this is. Could be completely off base. What Wikipedia has is that he ended up being convicted of voluntary manslaughter.
Okay, that's some jurisdictions have that. That makes sense.
Yeah. But again, the key principle there being that it wasn't something that he,
depressed people aren't capable of premeditation and deliberate. Again, I just think it gives you a motive.
Yeah. Like I said, I'm not sure.
Like, why did he do it? Well, because he was horribly depressed and thought this would help somehow.
Yeah. I'm not buying it exactly. And certainly, I read some of the other details. He arranged to meet the mayor. He had been like on the city board or something. He'd been involved in city government. He'd resigned. He wanted to take back his resignation, and the mayor wasn't letting him. So he arranged a meeting with the mayor and brought a gun there, and he ended up killing the mayor as well as Harvey Milk. That all sounds
bringing
like a
the
plan
gun. Yeah, when
me.
you in California, if you're carrying a gun.
Well, and evidently he evaded metal detectors at the entrance of City Hall.
Right, that's my point. Like lots of venues do not allow. It's not like some parts of the country where you just carry it with you everywhere as like a daily thing. It's even if you have a concealed carry permit, it's a huge hassle in this state to try to take a gun with you. If you're doing it, there's a specific reason why.
Yeah. So anyway, based on the evidence presented, I'm not sure the jury.
I'm not in favor of those laws, by the way. Those laws are terrible. I think you should be able to bring guns everywhere. But
But at any rate, so that the Twinkie defense mischaracterized in the media, but still,
I mean,
maybe...
barely mischaracterized. That was pretty accurate.
All right, so that's number one.
It's a bad defense. It didn't work, did it?
Well, it worked insofar as the jury convicted of voluntary manslaughter and not murder one.
It was charged with murder one. Yeah.
Yeah. Anyway.
Okay.
So that's number one. Number two, are you familiar with the dissolving mouse defense?
I think I've heard it. And again, none of these are like legally significant cases. So.
Right. Yeah. Well, in this one, it's defense is absolutely the wrong word for this because it's not even a criminal charge. It was a civil suit.
You defend civil suits.
Well,
you're a defendant.
Are you?
Yeah, plaintiff,
is
defendant.
That the terminology? I thought it was generally speaking going to be respondent.
No, that's if like it's a petition or something like that.
All right. Well, okay. So anyway, maybe defense is appropriate.
Petitioner, respondent. But it's plaintiff, defendant.
All right. At any rate, this one I think was from about 10 years ago. But basically, a guy claimed he bought a Mountain Dew, cracked it open, and found a mouse corpse in his soda. And understandably, wanted to hold someone liable for serving him a mouse corpse.
Yeah, that's pretty bad.
So he sued PepsiCo, which is the owner of the Mountain Dew brand. And the Mountain Dew defense was that they demonstrated that
a mouse could not remain in the Mountain Dew because Mountain Dew is so caustic that it dissolves the mouse.
That's exactly what they did. Yes, that on the timelines that it takes for a product to go from bottling to point of sale.
How is this not a bigger media story? Like, I feel like people wouldn't like it that the soda dissolves mice.
Yeah, and that's generally the tenor of the people who reported on this.
I'm surprised they didn't just pay this guy off. Like, if that's your defense, are you kidding me? Were these corporate lawyers or was this outside counsel they hired?
I believe this was the PepsiCo lawyer team.
Really? Like, I would think that they would have the company's PR. Like, they would understand that PR is more important than winning our case. But
you might. It's one of those things where I both believe that could be true.
Yeah, sure.
And that might not actually have any actual effect on, the health prospects of Mountain Dew, which is already, I'm sure, bad for you.
It sure sounds like it would.
Yeah, but it's
it
like... It
dissolves flesh. I'm made of flesh.
It's like there was apparently a trend back in like the 60s and 70s for science teachers to warn kids off of drinking too much Coca-Cola by demonstrating that it could dissolve a nail.
Yeah.
And then I remember hearing about this, and it turns out that like because of the chemical composition of teeth, that had absolutely no bearing on how it would affect teeth. Like enamel and iron are just so different that doesn't actually have any impact.
Well, I mean, like our stomachs have hydrochloric acid in them anyway. That would also dissolve humans.
Yeah,
so.
That's the other thing to consider is like how long is this actually in contact with your body anyway. Right. But you're certainly right that the PR does not sound great.
No, people wouldn't like that at all.
All right, and my final one.
Did they win? I want to know.
I believe they did win. Yes.
Yeah, that makes sense.
Yeah,
that makes sense. How much sales did they lose from it? What was the value of the lawsuit versus the sales they lost because of the?
Let me see if that's in the report that I'm citing here is from Scientific American, which did not really focus on the legal aspect so much as on the chemistry aspect. They don't say, and I think there's a very strong chance that they just reached a quiet settlement. But at any rate,
that's usually what happens here.
Yeah. This one, I'm virtually certain you'll not have heard of this one. Are you familiar with the fake heart attack defense?
No.
Okay. So this one, I'll show you the video clip in a second. There's this guy named Keeson Wilkins, something along those lines. A man defending himself in court, which, first of all, don't do that. General word of advice, not a good idea.
Yeah, if you, what is the expression? A man who defends himself in court has a fool for a client.
Yeah, he had apparently successfully defended himself on something like a simple assault charge, something like that. I'll go to the video clip here.
Did she inform you that she had family in another part of Ohio?
She did not provide me with that information, no.
She never provided with you? Excuse me, hold on a second. Your Honor, excuse me for a second. I need some time.
We're going to take a break, ladies and gentlemen. If you'll please step out. The record should reflect that the defendant is slouching over to the side and acts like he's sleeping. His breath appears to be quite normal. Doesn't appear to be labored in any way. Is that a fair assessment, sir?
Yes.
Not labored in any manner.
Yes, Your Honor.
Does he appear to be doing anything to you other than sitting in that chair?
No, Your Honor.
Oh, a remarkable change. Thank you.
Wow.
So those of you listening will not be picking up on here.
Yeah, he just grabbed his chest, said he needed some time, and then fell down onto the ground. Now he's slumping over in his chair.
Yeah. While the judge just sort of irritatedly looks around in frustration, I'll skip most of this. They bring out a full medical team because, despite the fact that the judge is obviously where he's faking, you can't just assume that. But they have medics check him out.
That could be bad.
Yeah, they have medics check him out extensively, say that there's nothing wrong with him. And as all of this is happening, and as the judge goes on to say, "Sir, if you don't stop pretending that you're unconscious, I'm going to hold you in contempt of court." He refuses to open his eyes and actually return to paying attention until they bring out smelling salts, and he does the most over the top sort of when they bring out the smelling salts.
All right. How did that work out for him?
Not well. I don't believe that the rest of that case went particularly well for him.
Yeah, I'm not surprised.
It was a bold strategy. I believe he was. Let me see if I can.
Okay, he really should have been. But again, pro per litigants get a lot of leeway.
Okay, so the brief report by the local ABC affiliate for the Chicagoland area where this took place doesn't mention being found in contempt, but he was convicted ultimately, and it was to a number of charges, including felonious assault, sentenced to 42 years in prison. So
that's a bad job. Felonious assault shouldn't net you 42 years.
I think it was probably both repeat offender kickers and a whole host of lesser charges as well. But anyway, so the fake heart attack defense did not pay off for him.
Doesn't surprise me a great deal.
Anyway, that was the pop quiz. You did pretty well, I would say. Definitely got the Twiggy defense.
I didn't know any of them.
Yeah, well, you got the Twiggy defense more or less correct. The Mountain Dew defense you basically guessed. And the fake heart attack.
I could see where it was going. Yeah.
Yeah. There's no way anyone had heard of that the fake heart attack defense, because I think this only happened.
It's not really a defense, is it? It's kind of just a way to get out of.
Yeah, it's just a litigate. That was what I was saying earlier, that the language is going to frustrate you, because a few of the reports on it use that phrase, but it's not a defense. It was just a desperation tactic in the courtroom.
Yeah. Just ask for a recess if you need it.
You'd think. Anyway, that's all we've got, though, for Captain Kangaroo Court.
All right, folks, thanks for tuning in to hopefully your favorite podcast, though that may be a bit overly optimistic. But we'll join you once again next week for Captain Kangaroo Court. That's all for today.
Yep. All right, and stick around for everyone's favorite, our series of disclaimers.
Of course.
Thanks for listening. Please note that nothing in this podcast constitutes legal advice, and all of the opinions expressed are the opinions of the individuals expressing them, not necessarily the opinions of the Lex Rex Institute.
The Lex Rex Institute is a nonprofit constitutional advocacy organization. If you'd like to learn a bit more about our organization's activities or make a donation, please visit our website, www.lexrex.org, LEXREX.org.
As a reminder, this podcast is a legal issues podcast, not a political issues podcast. We try to keep our commentary strictly to legal issues. Today, now that more issues are considered political than ever before, we believe it's especially important to distinguish between the two.
Thanks for listening to the Lex Rex Institute podcast, and we'll see you again next week.